Hello, everyone. My name is Roger Sahota, just for the benefit of the recording, and I'm a partner at Berkeley Square Solicitors in London. And I'm also one of the editors of the Red Notice Monitor blog, which is hosting tonight's event. And I'm delighted to welcome you all here this evening. Before we start, I just want to say a few words about the Red Notice Monitor, which is a platform which intends to shine a light on the work of Interpol. Interpol is, of course, an important international organization which performs a vital function in facilitating international police cooperation in the fight against international crime. And we at the Red Notice Monitor fully support Interpol in that mission. But what has become an area of concern for those of us, two areas of concern, I would say, for those of us, the academics, lawyers, observers who take an interest in its work, is how Interpol's procedures have been abused in recent years by some of its member states, and also by the lack of transparency generally about its work. So those two themes will feature quite heavily in our discussion today, which also takes place at a very opportune moment as Interpol's General Assembly is due to meet in Vienna shortly ahead of the appointment of a new General Secretary next year. So tonight we have assembled a panel which includes some of the leading commentators and experts on Interpol, and we'll be hearing from them on some of the challenges that the next Secretary General of Interpol will face. I'm thrilled to have as our first speaker tonight, Mr. Bill Browder. I'm sure you're all familiar with Bill. Bill describes himself on the blurb of one of his two best-selling books, the first publication, Red Notice, as an accidental activist, the Wall Street maverick who made his fortune in Russia and who, after his tax lawyer, Sergei Magnitsky's murder, spearheaded a global campaign in Sergei's name, which has transformed the way that governments across the world have to deal with reports of international money laundering and corruption. In the course of becoming Vladimir Putin's #1 enemy, Bill has been targeted by the Russian government for a number of illegitimate red notices, which have been published by Interpol. So there are a few people who can speak with as much authority as Bill on the reality of what the abuse of Interpol's procedures can mean to any one individual. And I'm very pleased and excited that Bill has been able to take time out of his diary to join us tonight. Our second speaker will be Dr. Ted Bromund, and I can speak from my own experience, having worked with Ted on a number of Red Notice cases, that he is one of the world's leading academic commentators on Interpol. He regularly writes about Interpol for various international publications, including publications such as Just Security and Newsday. And Bill and Ted has also appeared as an expert witness on Interpol abuse in many cases before the federal court system in the United States. In his day job, he is a senior research fellow in Anglo-American relations at the Heritage Foundation in Washington, and was the Associate Director of International Security Studies at Yale University until 2008. Ted tonight will speak about what is on the agenda at the General Assembly and how the election process is unfolding in the race to find the next Secretary General to take over from Jürgen Stock. So we're going to have Bill and Ted, which means that we'll start with Bill and Ted's excellent adventure, and then we'll move on to our third speaker, who is a lawyer and attorney who is joining us from the United States, and her name is Meg Hobbins. Meg is a partner at the Grossman, Young and Hammond law firm. She has over 16 years of experience handling complex US immigration and international human rights cases, and her practice includes a specialization in challenging persecutory Interpol red notices and restoring US travel privileges for individuals whose visas have been revoked or denied. and she has also represented clients before international UN bodies and the Inter-American Commission on Human Rights. So Meg regularly presents and publishes on US immigration and international law topics for professional organizations and bar associations. So we're very fortunate that Meg is joining us, and she will speak tonight about how in the United States, the Immigration and Customs Enforcement Authority have issued new guidelines and how red notices should be treated, particularly in immigration cases before the US courts. Our final speaker today will be Ben Keith, and Ben is a barrister at 5 St Andrews Hill in London, and together with our colleague who isn't on the panel tonight, Rhys Davis, the three of us are the editors of the Red Notice Monitor. Ben is a leading barrister specializing in cross-border and international cases, dealing with all aspects of extradition, human rights, sanctions, Interpol, and international law. He's represented governments, politicians, and military leaders, and has conducted cases before the Grand Chamber of the European Court of Human Rights and various UN bodies. He particularly specializes in political cases and regularly writes on Interpol and international law issues for various publications such as The Times and Newsweek. I think I'm right in saying that both Ben and Bill are shortly due to appear in a 60 minutes special feature on Interpol, which is due to be broadcast imminently. So something to watch, especially if in the United States, and look out for on a Sunday evening. So once we've heard from our panelists, we'll conclude with a question and answer session before some closing remarks. At the bottom of your screen, you will see a button that says Q&A. So if you do have any questions that arise while the panelists are speaking, then I would encourage you to just post the questions on that notice board, and we'll either deal with them whilst the speaker is speaking, or we'll filter them to deal with them later. So I think without further ado, I'll pass over to Bill. And Bill, please, can you begin?
Great. Well, Roger, thank you for the introduction. Great to be on this panel with such a highly talented and important group of people when it comes to talking about Interpol. Hello to the audience, and particular hello to representatives from Interpol who are on this call tonight. I'm glad that you're here because it's important that you hear what's going on and the issues that a lot of us have faced. For those of you who don't know my story, I will tell it in very brief. I was once the largest foreign investor in Russia. I uncovered corruption in companies that I was investing in. I decided to expose the corruption through the international media. That led to me exposing people high up in the Putin regime. I was, in retaliation for doing that, I was expelled from Russia in 2005. My offices were raided in 2007. I had a young lawyer named Sergei Magnitsky who worked for me, who investigated why they were raiding the office and discovered that the purpose was to confiscate documents which were then used in a complex tax rebate scam in which corrupt officials stole $230 million of taxes that we paid to the Russian government. He exposed the scam. He was then arrested by the same people he exposed. He was thrown in pretrial detention. He was tortured for 358 days, and he was killed on November 16, 2009, 14 years ago, at the age of 37. Since his murder, I've made it my life's work to go after the people who killed him and make sure they face justice. And when it became clear there was no possibility of getting justice inside of Russia, I said, how do we get justice outside of Russia? And that became known as the Magnitsky Act. The Magnitsky Act was a piece of legislation which I advocated for in Washington, which freezes the assets and bans the visas of Russian human rights violators. The Magnitsky Act was passed in 2012, and after it was passed, Putin went out of his mind. He in retaliation, he banned the adoption of Russian orphans by American families. He made it his single largest foreign policy priority to repeal the Magnitsky Act. And then he started to pursue me personally. Shortly after the Magnitsky Act was passed in 2013, I experienced my first Interpol notice in May of 2013. When that notice was put up, I happened to be in Norway giving a speech at the Oslo Freedom Forum about the Magnitsky case and the Magnitsky Act. And thankfully, it happened while I was there, but thankfully the Norwegian border guards, when I was traveling out, didn't actually put my passport into a machine. They just glanced at it and waved me through, or I would have been arrested. I got back to London, and I had my legal team write to Interpol and explain to them that the history of this story, that this notice was in retaliation to the Magnitsky Act. And the Commission for the Control of Files at Interpol reviewed our submission and came to the correct conclusion that this was predominantly politically motivated, violated Article 3 of Interpol's constitution, and rejected or deleted the notice on their system. Shortly thereafter, I think it was like 2 weeks after, Russia submitted another notice request. So this was a red notice request. And without any intervention from our side, Interpol rejected that. And that should have by far been the end of the story, but it carried on. And it carried on and on and on. And since those two notices, Russia has applied to Interpol 6 more times for either red notices or diffusion notices. And this led to me being arrested in Madrid, Spain in May of 2018. I was detained in Geneva shortly before that. Interpol claims publicly that there has never been a red notice for Bill Browder, sort of ignoring the fact that, yes, they rejected the red notice requests, but they allowed diffusion requests to go under their system on a regular basis. I'm happy to say that Interpol, when I applied to the Commission for the Control of Files, deleted the Russian requests on a regular basis. But the fact that I've had to face eight requests for my arrest from Russia says something that there's something really wrong with the Interpol system. The fact that Interpol doesn't automatically, both on the diffusion system and on the red notice system, knock out any requests from Russia for Bill Browder is a travesty. The fact that I've had to spend more than $1 million on legal fees to deflect this stuff is a travesty. Who else has got those kind of resources? What other activist has those kind of resources? None. And the fact that Interpol doesn't have a protocol for dealing with this. The Interpol's constitution says that if a country regularly abuses the system, they can be disconnected from the system. Interpol has never used that. And so, and for what it's worth, Russia continues to be a member of Interpol, chasing dissidents, activists, anti-corruption campaigners, and other people all around the world. It's crazy. It's insane. After Russia invades Ukraine, after they kill hundreds of thousands of people, after people protest the war, that Russia has the ability to use Interpol to chase dissidents and anti-war activists. And so Interpol's got a big job to do to become a sort of non-polluted law enforcement system. Interpol, in theory, provides a very useful mechanism for catching fugitives. But if corrupt regimes, dictatorial regimes like Russia and China, Venezuela, Iran, the United Arab Emirates, Saudi Arabia can use Interpol to chase dissidents for politically motivated cases, then it pollutes the whole system. It's like having a swimming pool, public swimming pool, which everyone loves to swim in the summer, and then people start using it as a toilet. Then it messes up the whole pool for everybody. And so I would argue very strongly that the next head of Interpol should be very much focused on trying to figure out how to legitimize the system so you don't have dictators, autocrats, and other bad actors abusing it for their own nefarious purposes. Thank you.
Thank you very much, Bill. So now we're going to turn to our next speaker, who is Dr. Ted Bromund. Ted.
Roger, thank you very much. Appreciate you and Ben organizing this panel. Thanks also to Bill for his leadership in this fight. Bill's emphasized the need for Interpol to make fundamental reforms. I agree with that, and the meeting of the General Assembly in Vienna will go a long way towards determining whether or not that remains a possibility. Just to put a few facts on record, the Interpol General Assembly will meet in Vienna starting November 28th, going through December 1st of this year. The location of this meeting is importantly symbolic. This is the 100th anniversary of Interpol's founding, also in the city of Vienna. And the formal business of the General Assembly will be significant as well. The General Assembly meeting will likely see the addition of Interpol's 196th member state. Sadly, this won't be Taiwan or Kosovo. It will be the Pacific island nation of Palau. The General Assembly meeting will also see an official announcement about the end of the Interpol Foundation, the much criticized conduit for funding from the United Arab Emirates. In my view, it's high time that this initiative, which never managed to raise a penny outside of UAE's contributions, comes to an end. Interpol has too often fallen for these sort of gimmicky fundraising approaches, from its early efforts to raise donations from corporations to its relationship with the corrupt football organization FIFA, to most recently the Interpol Foundation. It's high time, in my view, that Interpol recognize that as an international organization, it should be funded only by its national members, and that the cloth of its ambition needs to be cut to fit its budget, not the other way around. Speaking of ambition, the Secretary General Jürgen Stock will focus on the rise of organized crime and its dangers, and will, at this meeting, launch what will be known as the Vienna Declaration on Organized Crime. This is, of course, partly about needing to do something to mark Interpol's centenary, but also, I think, reflects a genuine sense of priorities in Interpol's leadership. I just wish that leadership was a little bit more focused in that sense of priorities. If you look at Interpol's website, it has 3 global areas it considers pressing, 4 strategic goals with 4 sub-goals for each goal, 7 global policing goals, and 17 additional areas of high priority focus. I really hope that going forward, that Interpol is able to trim down its priorities and that its member nations will focus on the most significant areas of activity. And that, of course, reflects the need for Interpol's member nations to be responsible, which is really the rub of the problem. That, in fact, will be the heart of the business at this year's General Assembly. First, this meeting of the General Assembly will see a vote on a proposal made last year by Russia that it should become impossible for any Interpol member nation to be suspended, no matter how badly it breaks Interpol's rules. Secondly, there will be vote on a proposal from Belarus that would require Interpol to publish red notices after a certain amount of time, even if their compliance with Interpol's rules hasn't been verified. In my view, both of these proposals must be voted down. Both are completely at odds with Interpol's constitution and would make it difficult or impossible to prevent politicized abuse of Interpol. Belarus has already been subjected to corrective measures by Interpol's Secretariat, which makes its resolution particularly self-interested and objectionable. And that really brings us to the heart of the business of this year's General Assembly, which won't appear on the agenda. In 2024, next year, Secretary General Stock will come to the end of his second and final 5th-year term. His replacement will be elected at the 24 General Assembly meeting to be held in Glasgow, Scotland. But a lot of the lobbying for that election will take place at this meeting of Interpol's General Assembly. Now, formally, it's the General Assembly itself that elects Interpol Secretary General, but the General Assembly acts on the recommendation of its executive committee, which has 13 members. But in practice, only 11 of those members will be voting, as 2 of the nations on the executive committee, Britain and Brazil, have fielded candidates to replace Jürgen Stock. The selection of the next Secretary General is vitally important for Interpol. I have never been shy about criticizing Interpol, but the current leadership has done some good things. It has imposed some corrective measures on some rule breakers. Important changes have been made to the CCF. Interpol's fundraising mechanisms have been improved. There is a new emphasis placed on increasing dues from member nations. There is, as Bill rightly notes, a lot more to do, but we should recognize the value of the steps that have already been taken. These steps matter because Interpol matters. Interpol is not one of those international organizations that is just for show. It does things that a lot of its member nations really value, and they are right to value it. The reason why the next Secretary General matters is partly that it's important for Interpol to take steps to decrease the abuses perpetrated through its systems. If Interpol is going to maintain its credibility, its transparency, its neutrality, and its accountability need to be further embedded into its systems. At its best, Interpol is about the rule of law. If it doesn't embody that in its actions and its personnel, it will rapidly stop working with any effectiveness, and what so many of its member nations value about it will be lost. So the election of the next Secretary General also matters because it will determine the extent to which Interpol is trusted by those leading member states. The reality is that Interpol depends very heavily on financial contributions and personnel from the US, Britain, Canada, and a very few other democracies. If those democracies lose trust in Interpol, it will not be able to work. And all the other nations that rely on Interpol to foster international police cooperation will lose out. These nations need to recognize the importance of their actions. Interpol is too important for them to vote on the basis of symbolism. I will note that the People's Republic of China is already lining up behind one of the candidates. None of the leading democracies in Interpol are likely to believe that a candidate sponsored by the PRC can be trusted to advance the reforms that Interpol needs, or, in short, to uphold the rule of law. So I'll close by noting that the election of the next Secretary General will be a pivotal moment for Interpol. It will determine whether the significant but still partial and incomplete reforms of the past few years are enhanced, or whether Interpol backslides. It will decide whether Interpol remains an organization that can do things that matter to its membership, or whether that membership prefers to vote on symbolism. It presents a straight choice between the rule of law versus PRC-backed authoritarianism in international organizations. This next year is the most important moment that Interpol has faced since 9/11. It may even be more important. The changes made to Interpol after 9/11 made it into what it is today. If reforms are not advanced in the coming years, it's Interpol's tomorrow that will be at stake. Thank you.
Thank you very much, Ted. So now I'm going to invite Meg to begin her presentation. Meg.
Thank you so much, Roger. Thank you for organizing this panel with Ben. It's such a pleasure to be here and an honor to be on a panel with Bill Browder, who's just done an incredible job raising awareness about the lifelong impact of being wrongfully targeted by an Interpol Red Notice, which is something that most of my clients don't, again, as Bill mentioned, don't have the resources to do, or even the reputational credibility to do. So greatly honored to be with you and appreciate your leadership on Red Notices. So as Roger mentioned, I'm going to be focusing on recent developments in the United States with immigration and customs enforcement. And I want to give a little bit of background about why this matters and what has happened and what may change. So in the United States, there's different approaches to red notices depending on the agency and depending on the target's immigration status. And what we see in the US is the Department of Justice, which acknowledges that you cannot arrest an individual on the basis of a red notice because they don't comply with the Constitution's probable cause requirements. So with DOJ, in order for there to be an arrest on a red notice, there must be an extradition treaty in place, a diplomatic request for extradition, and then a finding of probable cause for the charges underlying the arrest warrant. Then the US Attorney's Office can request an arrest warrant. So that is not the case with the Department of Homeland Security. So within DHS, we have the enforcement branch, which is Immigration and Customs Enforcement, or as we call it, ICE. For years, ICE has been targeting individuals solely on the basis of a red notice and arresting them under civil immigration law, not on the basis of their criminal charges, but finding civil immigration violations, arresting them on that basis, and then placing these individuals into removal proceedings, often on an immigration issue such as visa overstay. These are individuals that often have valid pending applications for a change of status or an application for asylum before the US Citizenship and Immigration Service. So these are not individuals who are being criminally targeted. This is really the Achilles heel of our enforcement system in the United States. It's being exploited, I'll say in good faith, unwittingly by autocratic states. So we have been dubbing these removal proceedings as backdoor extraditions. So instead of a requesting state having to present the documentation in support of an extradition, showing probable cause for the underlying charges and for seeking this person for prosecution, they don't actually have to do anything aside from getting a red notice published by Interpol. And then ICE does essentially the dirty work for them. So ICE has been targeting people, and then you are really on the immigration court conveyor belt. So prior to joining private practice, I clerked for over a dozen immigration court judges. Most of that time was halfway between non-detained and detained courts. I've also worked for nonprofits representing detained immigrants seeking relief from removal. So I've spent quite a bit of time in that system, and it has been described quite accurately as death penalty consequences in a traffic court setting. The immigration court, you do not have the federal rules of evidence. They are only persuasive. It is really a different type of system, and most of the detained immigrants in the US are not represented. And so to go into the system as the target of a red notice and being branded a, quote, alien fugitive, you are in an incredible disadvantage, and it impacts every single stage of the immigration process, starting following the arrest and then going to bond, where ICE has historically argued that anyone with a red notice is automatically a flight risk and a danger to the community. So immigration practitioners have been really bearing the burden of educating DHS prosecutors, Homeland Security prosecutors, and educating immigration judges about transnational repression through red notices, that red notices are not all the same, that there are autocratic states requesting red notices to harass and persecute individuals. And instead of being evidence of criminality, these are often evidence of human rights violations and persecution. So let me get back to the ICE policy changes. And I was trying to give the setup so everyone can be as hopeful and excited as we should be. So ICE announced at the end of September that they were going to have a new policy to take a more nuanced and informed approach to red notices. They said that this was in line with their commitment to comply with Interpol's constitution and rules, and DHS's Homeland Security's broader efforts to combat transnational repression. So even the most cynical among us, and I'll put Ted Bromund and myself in that category, it was really a jaw-dropping moment to see that framing of this new guidance. The guidance is designed to train ICE officers on red notices and on possible abuses from red notices. It is supposed to require verification that the red notice remains valid, that it hasn't been suspended or withdrawn. ICE officers are now supposed to conduct a preliminary review of the information for indications of abuse or non-compliance with Interpol's rules. They're supposed to seek supervisory approval to act on a red notice and also request underlying documentation through Interpol, through NCB Washington. They're also supposed to provide the targeted person with underlying documentation relating to the red notice. So it doesn't specify whether it's the red notice itself or potentially the underlying arrest warrant, but that is part of this new policy guidance. Finally, and this is really a big one, ICE officers are not supposed to represent or imply that a red notice or diffusion is an arrest warrant, or that it conveys independent legal authority or an independent judgment by Interpol concerning probable cause or the validity of the underlying criminal proceedings. This is that alone, to change that mindset is huge. So a few takeaways. Number one, we haven't seen the actual instructions. We've seen the ICE press release detailing and summarizing the directive. So it would be fantastic to see the actual instructions to ICE officers. ICE is working with advocates and practitioners to answer some of our burning questions about this. How is it going to be implemented? Who's going to organize the training? What will be the content of the training? What will be the accountability system? What about cases that are already in the pipeline? What about individuals that are currently sitting in detention who've had bond denied and are now facing an asylum hearing with a potential bar to asylum because of the red notice? So what about all of these individuals? What about individuals who've already been removed? Is there any hope? So where is this policy going to show real impact? I can't get into the details of it, but I will say I have personal knowledge of a recent arrest solely on the basis of a red notice. So no one expected the ship to turn around overnight. I can say that just with the guidance alone, it has been a very powerful advocacy tool in interactions with ICE. And I expect that to continue. So at the very minimum, this is a critical advocacy tool. It is very different to say, I have a report from an NGO about transnational repression and the abuse of Interpol, and instead be able to say, this is ICE guidance on Interpol abuse, and here's exactly what's happening now. Was this arrest on the basis of the red notice? If so, may I please see the red notice? To be able to talk with ICE and give them their own guidance is a massive shift in our credibility in advocating for our clients. So we are excited to see what happens. Again, I don't expect things to shift overnight, but we are very hopeful that things will change and that this Achilles heel of essentially allowing the immigration process to be co-opted through persecutory red notices, that will be, that will maybe come to an end soon. And in the meantime, advocates will have a powerful new tool to hold ICE to account.
Okay, thank you very much, Meg. So we're now going to turn to our final speaker, who is Ben Keith, and I think that he's principally going to speak about transnational repression and Interpol. Ben.
Yeah, thanks, Roger. I just wanted to sort of round up a few topics that have run through other people's discussions, namely the problems that we still see persist in relation to transnational repression, in that there are a number of countries who regularly abuse the Interpol system. In this particular discussion, we don't have time to go through them all, but we know that Russia and Belarus are prime examples of countries who abuse the red notice system, and they do it so flagrantly that not only do we have Bill's stories and many other stories of people who are on politically motivated red notices from Russia, but they are blatantly attempting to subvert the Interpol process in the General Assembly by getting issues voted through and motions voted through to prevent transparency. Other real issues are China. China and the UAE have tried to use Interpol fairly successfully to try and launder their reputations in both international organizations and international law. Meng Hongwei, one of the former presidents of Interpol, was held up as a great example of Chinese diplomacy and Chinese police competency, until unfortunately he was disappeared by the Chinese government whilst he was head of Interpol, with nobody knowing where he went. He turned up a few weeks later, paraded on TV, and was forced to confess to corruption charges, and he's now serving a substantial prison sentence in China. But we also know that China, a number of members of the panel have spoken about the problems of China and how the repressive regime targets the Uyghurs, targets dissidents, it targets ordinary people abroad, and there's a huge body of work in relation to the abuse of Interpol and in relation to the use of secret police abroad by the NGO Safeguard Defenders, amongst others, to show that the People's Republic of China is one of the key manipulators of the international order, and particularly it likes to use Interpol as a cover for its actions. By way of example, that China tends not to use Interpol red notices necessarily for extradition. It uses it to find individuals, and then uses its secret police or not so secret police who are stationed in foreign countries to attend individuals' addresses and persuade them in a forcible way, usually by means of threatening their families in China, to return to China voluntarily. And China have stated openly that this is their goal, and this is what they intend to use the red notice for, and they have heralded their success. And so there is a real concern that China will attempt to back a candidate for the General Secretary or put their own candidate forward. There have been some talk of that, and that I think we all on the panel would see as a significant detrimental step, which would destroy Interpol's credibility. The UAE have also sought to use Interpol to launder their own international reputation. They are trying to currently launder their reputation in COP28 by hosting the climate summit in order to show that they are a major player in international diplomacy. And they obviously have the president of Interpol, and Rhys Davies, Sir David Calvert-Smith and myself wrote a report about Mohammed al-Raisi, who's the current president of Interpol, and how he's been accused of being complicit in torture of not just British subjects, but UAE subjects. And so there are a number of regimes who may well be eyeing up the position of General Secretary, which would give them real power rather than a figurehead at the top of Interpol. And real power in the hands of despot regimes will effectively negate any ability of Interpol, in my opinion, to function properly, and will simply then be another tool to target dissidents and opponents in foreign states. Ted mentioned briefly one of my pet bugbears, which is the funding of Interpol, in particular the Interpol Foundation for a Safer World, a arm's length NGO set up in order for the UAE to funnel 50 million euros into Interpol's coffers in a slightly surreal arm's length deal, which you may think is coincidental in Mohammed al-Raisi being elected as the president of Interpol and the UAE managing to host the General Assembly on a number of occasions. And so we have to be very aware that Interpol is used not only individual red notices against individual people, both political opponents, business opponents of lower down the scale, ideological opponents of the PRC, and for many other nefarious reasons, but that Interpol itself, the organisation, is the target of corrupt regimes who seek to launder their reputation by saying, well, we are a significant member of the International Police Organization, we hold high office here, and therefore you can trust our policing. But for those of us who practice in this area, we know that the red notices are a significant and very dangerous tool for those people who are targeted, because it stops somebody from traveling. In many countries, it means that you are detained in custody. And once you've been detained in custody, stop traveling, or your bank accounts have been frozen because you are a high risk, then the red notice has done most of its job in stopping your political activities in any event. It doesn't necessarily require you to be extradited. And so as we move forward over the next year, a fair amount of lobbying, we suspect, from the different candidates, who actually, for once, 2 of them have gone public. And we hope to see who they are, and maybe even find out a bit about voting intentions, rather than what is extremely frustrating from a commentator's point of view, is what is a very opaque system of election and appointment of officials to the various committees and from the General Assembly. And so those are the warnings that I think we have to be very aware of. And those are just a few of the lowlights of regimes who we know from experience have used the Interpol system, and that we encourage caution going forward in making sure that those countries don't get a stronger grip on the levers of power within Interpol.
Okay, thank you very much, Ben. Now, we have quite a few very interesting questions, and I think I'm going to start with the most topical question, given that we are here today on the eve of the General Assembly, and that soon there is to be a new Secretary General appointed. So we have a question from Danielle Barden. Who are the candidates for the next Secretary General? Have their names been released publicly, or is this kept private? And it was mentioned that there is a candidate supported by China. Who is that candidate, and where is that candidate from? So perhaps Ted, please, could I ask you to address that first?
Sure. There are 2 candidates, as I alluded to, that have publicly declared, and I believe that those are the only 2 candidates who are in the race, although it's not possible to exclude the idea that there might be another candidate emerging at some point. One candidate is Valdeci Urquiza, a Brazilian national who currently sits on Interpol's executive committee. Mr. Urquiza has visited the PRC and the UAE, for that matter, and you can see, if you look at Mr. Urquiza's Twitter feed, you can see pictures of him meeting with the Chinese authorities, as well as a number of other regimes around the world. The second candidate is Stephen Kavanagh, British national. Mr. Kavanagh is currently employed at Interpol as the Director of Police Services. This is probably the most important job at Interpol below the Secretary General position, certainly a very high-ranking job. Mr. Kavanagh was formerly the Chief Constable of Essex and has an extensive law enforcement background. He has also publicly declared his candidacy on Twitter and has been publicly backed by the UK government. And you can see all of that on his Twitter feed as well. There was at one point the rumor of a third candidate from Zambia. It's believed that this individual was regarded in initial screenings by the executive committee as not senior enough to go forward. So right now it's Kavanagh versus Urquiza, the UK versus Brazil. And if you look at the nations on the executive committee, that is the nations that basically decide who the next Secretary General are going to be, ruling out Britain and Brazil, there are 11 nations. The UAE, which appears to be backing Urquiza, Belgium, Nigeria, Argentina, the PRC, which again appears to be backing Urquiza, the US, which I feel fairly sure will support Kavanagh, Spain, Namibia, Turkey, Egypt, and India. I wouldn't like to make any forecasts, but I can see a number of votes in there that are likely to go for Urquiza. So it's all the more important, if the British candidate is going to win, that the US, Belgium, and the other democracies in that group get behind Kavanaugh, who I view as by far the most creditable candidate for a number of reasons, but simply for the purpose of this panel, because he's not apparently being backed by the People's Republic of China.
Okay, great. There was a recent blog that we published at Red Notice Monitor, Ted, on the election race, and I think that the odds that we gave in a rather joking, light-hearted fashion was 3-1 on Mr. Akiza and 4-1 on Mr. Kavanagh. So that article was published in October the 18th. What do you think of those odds, and have they changed since then?
I'd put it sort of more at 50-50. I think Mr. Kavanaugh has got a very good chance of winning. If you just look at sort of the political orientations of the nations on the executive committee, it might not look particularly easy for him to get to the 6 votes that he's going to need. But there are all the realities that I alluded to in my remarks. A lot of nations out there, I'm thinking of, for example, a nation like Namibia, which sits on the executive committee, they really value Interpol because it's one of the very few ways that they can connect directly with police agencies around the world. And we all know that can be abused, but it can also be put to very good purposes. Nations like Namibia really have a lot at stake in this vote because the election of an individual who's seen to be, and maybe even is, PRC backed would immediately be perceived as a fundamental attack on Interpol's credibility in a lot of democracies.
Okay, thank you. And if anyone is interested in learning more about Mr. Kavanagh's candidacy, we did publish a blog on this on November the 8th, which includes a link to a very glossy brochure produced in support of his nomination by the UK government. We haven't really seen anything similar produced by the other main candidate, Mr. Akiza, but if there is anything, then we'll be certain to publish it. Moving on, we have another question. I'm going to address this one to Ted. So, sorry, Bill. Bill, the question is, do you have confidence, and this is from Natasha Draycott, do you have confidence in Interpol's ability to prevent the publication of another, we've had 8 already, abusive red notice against you in the future?
The answer is no, I don't. I mean, at the moment, we're in a world where the Jürgen Stock has pretty much given instruction not to honor Russian red notices against me because he's worried about the institutional damage that would do. But Jürgen Stock won't be there soon enough, and you know, Russia is a paid-up member of Interpol. I'm not. And I've seen this happen so many times before where people become very officious and they say, well, is the arrest warrant properly issued by a court? Yes. Has it been transmitted on our system? Yes. You know, is it a crime that would be, I can't remember the legal terminology that rises to the seriousness of Interpol? Yes. And then they put it on the system. And there's no reason why there wouldn't be a 9th red notice for me. And for that matter, there's it also depends on who's part of the Commission for the Control of Files. There was a time at the Commission for the Control of Files where the Russian official who was responsible in the prosecutor's office for sending out the red notices eventually joined Interpol's Commission for the Control of Files that was considering my challenge to the red notice. I mean, the Interpol is kind of like the UN, where you got all these crazy countries like Iran and Saudi Arabia on the Human Rights Committee. It's entirely impossible to predict how the absurdity of this organization works. In my mind, I think that the governments, the sort of civilized governments, the rule of law governments, the non-dictatorship governments, who actually make up a majority of the funding for Interpol, need to work together to clamp down on all this nonsense, because otherwise we're always at the mercy of the situation just spinning out of control with some new person in charge or some pressure being placed by a rogue regime like Russia.
Excellent, thank you. Well, that dovetails nicely with our next question, which is from a Mr. Davis. And that is, I'm going to ask Ben and Meg perhaps to contribute to this, which is a question about what suggestions and proposals do you have for the reform of Interpol? Ben?
One of the key things that I think would be helpful is more transparency in the process. And that's the process of election of candidates, of how votes go in the General Assembly. And that's candidates for the General Secretary, that's candidates for the presidency, that's candidates for the Executive Committee. Because we don't know how it works. We don't know who is voting for who. We know that lobbying goes on. It's essentially a political game, but we don't know who is lobbying for whom, and perhaps we won't know that. But we don't see the results, and so we don't know who has voted on the people onto the CCF. I mean, the CCF is a reasonably independent body these days, but the previous iteration of the CCF contained a Russian member, former member of the Ministry of Interior, who was in charge of international policing, and was a man who'd in fact issued a number of politically motivated red notices against several of my clients. And one day, I got a response from Interpol refusing to remove a red notice of one of my clients, one of the few that I haven't managed to get removed. And at the top it said, well, he left the room whilst we discussed the red notice that he had issued against your client 6 years beforehand. And that the Moldovan on that committee was reported to have links to organised crime, and so you had a CCF that were not, well, they weren't competent necessarily. It wasn't that they were all bad, but it was a very mixed bag, and so you couldn't have confidence they were going to make good decisions, and that they often make political decisions. And so I think a real reform would be to show the workings and the election process of some of the major committees of Interpol.
Excellent, thanks. I think we've heard a lot today, in particular, about red notices, a pattern of abusive red notices that have emanated from 3 countries in particular: Russia, China, and the UAE. I have a question for Meg, which is just to ask you what the attitude of the State Department is and the US courts to red notices issued by those particular countries. Is there any sort of consistency in their approach?
So there is not a recognition in terms of categorizing or banning individual countries or qualifying red notices from Venezuela or from Russia or from China as categorically unreliable. There is case law saying that if there is a pattern of abuse, this is to be taken into account by the immigration judge, but they're not following any specific guidance. And the State Department actually, in the recent TRAP report, has declined to designate individual offenders. So we're not seeing that kind of naming and shaming that we maybe wished we would get with recent legislative change in the U.S. And one thing I would add, just to go back to the question of what reforms you want to see, to echo Ben, we need greater transparency. And I specifically see this with the Commission for the Control of Interpol's Files, and I'm also hoping for greater transparencies with the Notices and Diffusion Task Force. So targets of red notices are utterly in the dark, and they're in the dark for 9 to 11 months or longer, right? So if we could have a little bit more insight into where we are in the process, and also with preemptive requests as well, what kind of protections people should have. Bill mentioned that he has no confidence that there won't be yet another red notice. So to have some kind of accountability and reliable enforcement system for people whose red notices have been deleted or who've lodged valid preemptive requests before the commission. The other thing I would mention is again, just the timing is excessive for individuals in detention or facing removal proceedings out of detention. Their legal system is moving forward faster than Interpol is reviewing and assessing and deleting red notices.
Okay, excellent. Thank you very much. I'm going to just draw the meeting to a close. I apologize to some people who would have sent in questions. We only have an hour, and so we didn't quite have time to address all your questions. But we'll try and have another meeting hopefully in the future, because one of our aspirations is that this is the beginning of a dialogue. We know that a representative or representatives of Interpol and other international organizations and countries are here. So we hope this is the beginning of a dialogue with Interpol. We'd very much like on the Red Notice Monitor to engage with Interpol on these issues. And we have, for example, been in contact with some of the candidates who are standing for Secretary General, and we have approached them with requests for them to write to us to set out their vision for Interpol, and in particular to identify what steps that they would propose to take to stamp out Interpol abuse, which has been a theme throughout this meeting. So I'd like to thank all our panelists today for your time, and I'd like also to thank all of you that have joined the meeting. I hope you found it as informative and interesting as I have, and we hope to see you all again soon. Thank you very much, and good night.
Thank you.
Thank you.